Welcome, everybody. I'm Alan Gelb. I'm here as a representative of Indivisible Columbia, New York. And tonight, our special guest is Tom Gerety. Tom is the past president of Trinity College and Amherst College. Amherst, he became the director of the Brennan Center for Justice at NYU Law School, where he was also the Brennan Chair, and then held the Collegiate Chair, teaching at the law school and at the college. Tom and his wife, Adia, are full-time residents of New Lebanon, where they're active in local politics on the right side, I might add. Tom, let's begin by laying out the various cases we're going to talk about tonight, and then we'll take questions. Some folks have sent questions in advance, but if any of your questions are not answered tonight, we will try to get back to you on them. No promises other than that we will try. Tom.
All right. Thank you, Alan. Thanks for having me and for making an effort to get everybody together to talk about these interestingly important and, in some sense, novel cases that our former president has presented us with as he attempts to become our once and future president, and most of us attempt to stop him. There are 3 Trump cases at the Supreme Court, but one of them does not directly involve Trump. So I'm going to talk, and I hope this will be a conversation. There'll be lots of time for people to at least post their questions and get some, have their curiosity satisfied a little bit. First, there's the question of immunity from criminal prosecution. Going up in front of the Supreme Court now, almost certainly when the Circuit Court of Appeals, and I'll say something more about this in a little bit, decides its case, but possibly not. But in any case, the question of whether President Trump can, and he's already been in the district court and he's already been to the Circuit Court of Appeals this last week. Is everything all right? I see Karen.
Sorry.
Yeah, okay. So the criminal immunity, that is to say the immunity from criminal prosecution of the former president of the United States for acts committed during his presidency. And I'll say something about that in a minute. The second question is the one that I think an awful lot of people are paying a lot of attention now, and that I can't help but interest us all. It's a very novel question since the Civil War, and that is, under the 14th, is participation in an insurrection a bar to running, or to holding, I should say, the presidency or the vice presidency? And we'll go into that case, which is definitely coming before the Supreme Court out of Colorado. You all saw in the last couple of days, a lower court judge in Maine barred the decision, or held up the decision, postponed the decision until the Supreme Court decides. And the third case I'm going to talk about, the Fisher case. Fisher is a Boston cop who retired to Pennsylvania and participated with so many others in the riotous insurrection on January 6, 2021. Fisher has raised a question that goes right to the heart of Jack Smith's 4 charges. That is the application of a financial statute, Sarbanes-Oxley from 2002, to the rioters and insurrectionists. Is that application legitimate? Statute has a term, corrupt interference with federal procedures. And is what they were doing a corrupt interference with federal procedures, is the question in that case. And Trump is not in that case. He's not named in that case, but it's directly relevant to to the charges, to 2 of the charges, at least, that Jack Smith is bringing against him. So let's start with the immunity of our presidents from prosecution when they leave the presidency. And the first thing that this immunity, and we're talking criminal here, but it could be, we know something about civil immunity because it came up with Nixon and with Clinton. And obviously someone in this position can have committed criminal acts or civilly liable acts before taking the presidency, arguably during the presidency, or after the presidency. So we're confining it to the period of the presidency. And the question is, Trump, who was impeached twice, is he, despite acquittals in those 2 impeachments, including the last one, which was directly focused on January 6th, is he subject a criminal prosecution like the one that Special Counsel Jack Smith is bringing right now against him, with the trials hopefully this spring. The first thing to say, there's nothing in the Constitution that says the president is immune from prosecution. But there is a sense, which has been reduced to a memo way back in 20 years ago or so by a law professor named Ronald Rotunda, who at that point was in the Justice Department in the Office of Legal Counsel, that suggests that no president should be subjected to criminal prosecution. And for those of you, at least during the period of the presidency, many of us remember Robert Mueller seeming to become befuddled or hesitant at the time of his investigation. Am I right about that? I mean, I assume I'm right. I can't see your faces, all of them, but I'm assuming that that's a nod. Mueller just seemed to be, in writing up his report on Trump and the Russians and so on, seemed to be unwilling to go all the way to say this is a crime and the man should be prosecuted for it. His hesitancy was based on this opinion in the Office of Legal Counsel in the Justice Department that you don't charge a president with a crime. And the reasoning there, which has no textual basis whatsoever, is that our president, our acting and serving president, cannot be restrained by a criminal prosecution while performing the tasks of the presidency. I hope that's clear. In other words, it simply is a reasoning from the job that it would get in the way of doing the job well were the president to be subjected either to a criminal trial or to jail if convicted. And since we have impeachment right there in the Constitution, the assumption has been that the way to get rid of a president who's involved in high crimes and misdemeanors is to subject that president to an impeachment. We now know, with the terrible polarization and sort of gridlock in Congress and the Senate too, that we're very unlikely to have an impeachment in the present conditions that's successful. And we'll see with Mayorkas, the head of Homeland Security, whether the Republicans will be able to pull it off. It looks like they may be able to just barely impeach him, but it looks also as if they won't be able to convict him. When it goes to the Senate, it's almost certain they won't be able to convict him. So this first question about the criminal immunity of the president, what is the Supreme Court likely to do, is the question most of you are going to have on your minds. And my answer to you is they're likely to follow the opinion filed by the Office of Legal Counsel saying that a president should not be charged while in office. Then arises the question, can they be charged when they leave office? And this case came up 10 days ago or so to the Circuit Court of Appeals after Jack Smith tried to get it rushed up to the Supreme Court. What happened is that the district judge before whom the Trump charges, those 4 charges related to the his encouragement and participation in, really, the January 6th uprising, Tanya Chutkan, who many of you have seen in the press, decided to allow an interlocutory appeal. That is to say, before the trial even gets going, let this appeal go forward because the claim is you can't charge me with these crimes and therefore I shouldn't have to sit through a trial. It's rare that an interlocutory appeal is allowed in a criminal trial, but it was allowed. It went to the Circuit Court of Appeals, and the 3 judges, one of whom was an appointment of H.W. Bush, I think, but of one of the Bushes, was somewhat less certain than the 2 Democratic appointments. But many of you were the press last week, in which Judge Florence Pan, who came up through a district judgeship in Washington and was only very recently put on the Circuit Court of Appeals, raised the question of SEAL teams called out by a president to assassinate someone running against him or her in a presidential contest. Could a president get away with committing a massive murder, really, or worse, and never be charged with a crime because that occurred during the presidency? And the very hypothetical, that sort of question seem to suggest to the all the press and commentators and constitutional scholars about this that it's very, very unlikely that they're going to say that a president, once having left, is immune from prosecution. Now, there's another twist on this. Sowers, S-A-U-E-R-S, the Missourian, who's a damn smart lawyer on the right side of things, on the reactionary right, I should say, made the claim that that Trump was acquitted twice in impeachment, and it says right in the article of the section of the Constitution on impeachment that the punishment of an impeachment is you're kicked out of office, and you can be prosecuted later. So Sauer takes that as a kind of reverse piece of logic and says, well, since it says right in the Constitution that a successfully impeached and convicted officer or president can be charged later, he takes it to mean he can't be charged if he's acquitted. And of course, Trump was acquitted. It's not, by any normal standards of logic, it seems like a real stretch of an argument. What the Constitution says is, if you're successfully impeached, you can be charged. It doesn't say if you're unsuccessfully impeached, you can't be charged. And so most of us think on this question, and we can put this aside with this, that this will be one that the Supreme Court either throws out on procedural grounds, saying we shouldn't have taken the interlocutory appeal, or simply says, yes, a president can be convicted. And it's likely to be, on such an important question, close to unanimity and possibly unanimous decision. But that's a guess, and it's a guess that I share with a lot of others, but I welcome any questions on that. So that's question number one, maybe going to the Supreme Court if the Circuit Court of Appeals agrees. Is the president, after his presidency, still subject to criminal charges like the 4 charges that Jack Smith has filed in the district court in Washington against him? Question number 2, the one that's been in the press and you're all very interested in. Didn't he participate in an insurrection? And if he participated in an insurrection, isn't he under the 14th Amendment, Section 3? And I'm going to ask Aileen, whom I should thank for helping out in this, to throw the 14th Amendment little thing up on the screen. Well, there's the author, a very strong abolitionist from Ohio named John Bingham. And now let's see if we can get the text up, Aileen, of the 14th Amendment. And let's see if we can expand it as much as we can on the screen. So most of you are very familiar with the due process and equal protection clauses of the 14th Amendment in Section 1. Most of you are less familiar with the Section 2, and I'm not going to go into it, but it's about the apportionment of representatives and the end, really, of the 3/5 clause in the Constitution. Although you'll notice it's the first time, it's the next to last sentence of Section 2, in which male citizens are specifically named and female citizens are not. That would, of course, change with the suffrage and the suffrage amendment. But look at Section 3 here. This is the one that we're looking at in this question about insurrection. No person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, an oath to support the Constitution, no person shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof, can serve in this way. So that very good, Aileen, underlining all this. But Congress, made by a vote of 2/3 of each house, remove the disability. Lincoln and Andrew Johnson both pardoned. Now, this is not the same. I want you to note this. This is not the same as being charged for treason for having participated, for instance, in the Confederate side of the Civil War. Both Lincoln and Andrew Johnson pardoned participants in the Civil War on the Confederate side in that way. Whoops, we've lost it. But this question raises the question which Colorado, Maine, and many other states have taken up, namely, can a Secretary of State, can a court in Colorado, can, depending on the laws of any given state, can some state officer with the proper responsibility to certify primary candidates and electoral candidates say, we are going to exclude Donald J. Trump because he participated, and we know it, in an insurrection on and around January 6th. In other words, aiming towards January 6th and then on January 6th. And this is indivisible. Many of us think it's sort of irrefutable and obvious, self-evident that he did participate in insurrection. But there are obviously a lot of people in the country who would say, well, not really, or he didn't participate, or he didn't mean it to happen that way, and who certainly would say they don't want him taken off the ballot in Colorado, Maine, or anywhere else because of this, his actions and his actions and discussions in relation to this. So this matter is, yes, before the Supreme Court, definitely before the Supreme Court. And again, the question is, what is the Supreme Court going to do? Maine, just as I said a moment ago, a judge in Maine just held up the decision of their very impressive Secretary of State, who was in charge of elections, by saying we've got to wait for the Supreme Court to opine on this, assuming they will, and I believe they will. I'll take questions on this in a minute. What do I think? Many of you will wonder, and what do a lot of constitutional lawyers and commentators think? Most of us are of the view, despite the fact that it's not in the language of the 14th Amendment, that this is not to be decided on a piecemeal basis, state by state, that there has to be some mechanism, probably our very gridlocked Congress, to say that someone participated. And we can talk about why, but essentially I would say to you that what happened in the Civil War showed the insurrectionists and rebels very, very clearly by joining the Confederacy. And since we're talking mostly about senior members of the Confederacy, because you would have had to have previously taken an oath as a member of Congress, an officer of the state, and so on and so forth, it was very self-evident who was and who wasn't a member of the Confederacy. There were spies and so on, but on the whole, everyone knew who was part of the Confederacy and who was not. And the country, in that sense, was very clearly divided. And so this section of the 14th Amendment, while it may have been somewhat self-evident and thus self-enforcing in a sense at that time, is, I think it's fair to say, not self-evident and self-enforcing now. It requires some authoritative decision that was an insurrection. These and those people, including, in this case, Donald J. Trump, participated in it. And that, I think the Supreme Court will decide. What do I think they'll decide? I think they'll decide that legislation by Congress would be required, saying that all people, say, convicted of participation in the January 6th insurrection, are any of those who held such an office and swore such an oath, would be denied the ability to run for one of these offices. And then the question would come, what about the presidency? You'll notice the presidency isn't mentioned. There's a group of scholars who believe that it was not mentioned on purpose because people thought it was either inconceivable or unnecessary to say, while senators and representatives might come from South Carolina and the other Confederate states. It seemed to them, one can argue, inconceivable that a president would. Another interesting issue here is that electors of a president can't hold office if they participated in the insurrection in the Confederacy. In those days, and going back to the framers in the last decade of the 18th century, the Electoral College was seen as more like a jury than it is today, more likely a deliberative body that would think about whether the people who are coming forward should be president and might, in a sense, vote against them. We've had decisions and about the faithless electors a couple of years ago, where we don't really treat the Electoral College as a deliberative body anymore. People say where they're going to run as an elector for a given candidate, and they show up and they vote for that candidate. And in the faithless electors case, the Supreme Court decided that yes, the states could punish you if you didn't vote for the candidate you said you would vote for. The final thing here about this question is the Section 5. The Congress shall have power to enforce by appropriate legislation the provisions of this article. Under the Section 5, we get the civil rights laws, all the Title VIIs, Title IXs, and so on and so forth. It seems like, while it was not necessary to say we had a due process clause or an equal protection clause to have legislation like this, it seems like in this case, Section 5 would be a natural home for the decision, was it an insurrection, and on what basis and with what process do we find that people have been insurrectionists and thus are guilty of this. Now, I want to turn, and I'm doing all three issues, and then we'll take questions and so on. I want to turn to the question of what is a rebellion or insurrection? And I want to tell you right off the bat that the Constitution does not define it. Indeed, the statutes don't define it. So here is 18 U.S. Code 2383, rebellion or insurrection. And you see right in there, whoever incites, sets on foot, assists, or engages in, and then rebellion or insurrection. The key language here is probably against the authority of the United States or the laws thereof. In other words, as in Shays' rebellion in Massachusetts or the Whiskey rebellions out in Pennsylvania, at the very start of our constitutional system, there were people who actually, defied the law, just as the later Confederates defied the law. And I think a proper interpretation of all this is that the various statutes that have become the Insurrection Act, and there's a whole lot of legislation behind this that got amalgamated here, we're really looking at situations like the situation on January 6th, where people rose up against the laws of the United States, just as they rose up against the election and tried to overthrow the certification of President Biden's pretty clear victory, upheld in very many states by very many courts. It looks to me like an insurrection, but it's not defined in the statute and it's not defined in the Constitution. Sometimes the other word that comes up, because they're, as you know, the Proud Boys, several of them have been convicted with very stiff sentences under the seditious conspiracy language in the next thing down here, Section 2384 of the U.S. Criminal Code. And there we have a somewhat more detail: conspiring to overthrow, put down, or destroy by force, levying war, opposing by force the authority, to prevent, hinder, delay the execution of any law, or by force to seize, take or possess any property of the United States contrary to the authority of, and then 20 years or fine. And that, again, it gets much closer to a real definition. Usually, if you look at a law dictionary or any dictionary, sedition can be engaged in by speech, like what we used to call back in the anti-communist days, in the McCarthyite days, subversion and so on, or by just talking and arguing and saying different things. That's especially a series of constitutional First Amendment cases have eliminated mere talk as a criminal action in most such cases. And I say here, sedition usually can stop its speech, while rebellion and insurrection would seem to normally require violence. So in the Fisher case, and now I'm going to ask Aileen to put up the Sarbanes-Oxley language. That other box I have there. If you all remember, I mean, we're most of us old enough to remember the Enron collapse and prosecutions, where people had a huge corporation worth a fortune before it began to fall apart. And when it came time to clean up the mess and prosecute some people, a lot of records had been wrecked, had been destroyed, hidden, literally shredded and so on, mutilated and so on. So in the lengthy Sarbanes-Oxley, there's lots of stuff about how corporations have to conduct their business, public corporations, and so on and so forth. In one section here is 1512C, and this is a very lengthy statute. Whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with intent to impair the object's integrity or availability for use in an official proceeding. That person is guilty of this section 1 of 1512C. Now, look at section 2. Or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. This language in Sarbanes-Oxley 1512C2 is precisely what Jack Smith uses in 2, and arguably it touches a third of the charges against former President Trump in the district court in Washington, because he's being charged with 3 conspiracies: a conspiracy to defraud the United States in order to prevent the counting of the votes properly and certification of the election, a conspiracy to obstruct the actual certification process. The third charge is an actual obstruction, which is and an attempt to construct, and a fourth charge, which is a conspiracy against the voting rights of the people who voted in the election. And 2 of those would seem to touch on this notion of attempting to obstruct or impede. And if the Fisher case goes against the application of this statute to Fisher, the retired Boston cop, to a guy named Lang, who lives on the other side of the Hudson, on the western side of the Hudson, and a guy named Miller, who I think has already pled and is serving time, if that happens, then I think 2 of the charges that Jack Smith is bringing are simply going to fall away as unconstitutional, or as an invalid application of Sarbanes-Oxley to something that's not really a financial transaction, but is, as we're saying, an insurrection. The final thing I want to mention here, and then we should open it up, is many of us have been paying a lot of attention to Fani Willis prosecution in Georgia. It's a complex thing. There are a lot of people involved. She's gotten some people to plead guilty already, and made plea bargains with them. We all know Giuliani's involvement in this thing. And now Fani Willis gets right up there in the headlines with a kind of a scandal, namely that she is said to be romantically involved, sleeping with Nathan Wade, one of the 3 special prosecutors that she's hired in order to bring this massive racketeering case under Georgia law. The one case that even if Trump were in office, he couldn't just wash it away by pardoning everybody as a violation of federal law. And I was saying, Alan Gelb and I were talking about this earlier today by text and email. This is a really troubling problem, not because a prosecutor cannot pick her romantic partners as she will. It's a big problem because she's picked a guy who really has almost no qualification for prosecuting a massive case like this. 1, 2, she's paid him a lot of money. She's signed a contract with him to be a special prosecutor. And in Georgia, as in lots of other states, that's a conflict of interest. You can't, it's a conflict of interest right here in our little towns in the Berkshires. You can't, without real problems of conflict of interest, hire your brother, your sister, your lover, your wife, your husband, your partner for matters like this. It's not at all clear yet what Fani Willis, what her relationship to Nathan Wade is. What is clear is that he's pretty unqualified on the face of it to be doing this big prosecution, and that he's gaining a lot of money. His experience is essentially that he got himself elected to one of these local traffic courts and was a judge in traffic ticket questions. And otherwise, he seems to have practiced divorce law and family law and some very small business corporate law. And I don't know if he was successful or not, but it would seem that his friendship with Fani Willis is what brought him into this place. Now, a final thing I'd say about this is as many of you know, she was forced to step back from the prosecution of the man who's now the lieutenant governor of Georgia, because it was said she had a conflict of interest because she had given money and maybe worked for his opponent. On this question, I think her whole prosecution could collapse, because if she's replaced by some Republican, conservative, or right-wing prosecutor, and most of the prosecutors in the counties of Georgia are, and she is replaceable. There are definitely a couple of statutes in Georgia under which she can either be impeached or forced to withdraw. I think they'll appoint somebody who doesn't have her inclination to go after Trump's allies. And that's a scary thing for those of us who felt this was a prosecution that could really make a difference. Okay, let me open it up, Alan. And I know that sort of wandered around some complex matters. I can't hear you.
No, I have to unmute Alan.
Yeah. Oh, you're the boss of that. Thanks, Aileen, for doing that.
I just have to unmute Alan. So let me just find him here.
Oh, you have to. All right. And so let me just review the bidding. We got 4 things we're talking about here: the president's criminal immunity, the question of insurrection as a bar to running for the presidency, the Fisher case, which is the application of the Sarbanes-Oxley financial statute, corrupt interference with a federal procedure. Aileen knows a lot about that, I think. And finally, the terribly difficult question of what the heck did Fani Willis do when she hired Nathan Wade to be one of her 3 special prosecutors, and paid him so seemingly lavishly over the last couple of years.
Okay, Karen, Alan, you can unmute yourself. Okay, there you go.
All right. Yes, that was a stunning moment when Tom told me about Fani Willis's situation today. And
have I clarified it? I mean, we might as well, why don't we take that one first? I mean, is it clear what's going on or no?
So,
I mean, not the facts yet. We'll hear about the facts. The judge just ordered filings and hearing.
I guess what I'm curious about is, why would it be an impeachable offense to select somebody for your prosecutor who's not that experienced? I mean, plenty of people appoint people who are not that experienced to things, right?
If she had, I mean, let's assume she's innocent. So if she had not had if she did not have a relationship with him that you could describe as sexual, romantic, family, et cetera, even a friend, I think she could have done it and gotten away with it clean and, fair and square. It's just, you can't hire your kid to be the highway superintendent if you're the mayor or whatever, or if you're the prosecutor. You can't hire a special prosecutor if it's somebody you're already involved with. And it's not clear when she got involved with him, 1, and 2, it's not clear what her involvement is, although it seems very likely on the basis of inferences from what's been said and filed so far that he is her boyfriend, and that he may have been earlier, or it may have developed over time with this prosecution. But the problem is that Georgia has 2 methods of going after prosecutors. They have an association or a council of prosecutors, of the county prosecutors from the whole state, and they have the power to remove somebody. And most of those guys, or most of that gang, is pretty right-wing. 1, so they have a power to remove somebody that they consider is doing a bad job. And secondly, there is an impeachment bill that the governor signed just a few months ago that allows you to impeach prosecutors and actually toss them from office.
We do have a follow-up question on that. Can you describe just how lavish his compensation is?
Somebody said it was up to $1 million, but the Times reported 650,000 over a couple of years for, I don't know if it's full-time or part-time work, but it doesn't look good. It looks terrible. It's feeding already into Trump's awful rhetoric and, witch hunt, racist prosecution, et cetera, et cetera. And I think to any of us who cares about upstanding, if it turns out that he was her romantic partner or sexual partner when he was hired, it really looks terrible, and I think will lead to consequences for her, to her getting in a position politically where she's not going to be able to defend herself. Those prosecutors from the county, the whole county, all the counties of Georgia can go after her, and the governor can go after her, or the legislature with this impeachment thing. So it definitely jeopardizes what was already a huge, complicated, difficult prosecution, but one that seemed to be having some success with these plea bargains.
Well, we're seeing a lot of things sort of potentially falling away. Two of Jack Smith's charges, this case, what can we actually get this guy on?
I think Jack Smith can get him. I mean, let me go back. Can we go back to Sarbanes-Oxley for a minute?
Sure.
Okay. Sarbanes-Oxley is a financial statute. I mean, it's a complex regulation of, and this is just a little piece of it. It's a complex regulation of accounting practices, record keeping, et cetera, et cetera, et cetera, for corporations and public corporations, I think, publicly held or traded corporations, but possibly private as well. In any case, it may seem surprising to people that this 1512C2, otherwise obstruct, influence, or impede an official proceeding, would be applied to what is a violent riot at the least, and as we're saying, a violent insurrection against an election, a presidential election. But it has so been applied many, many times before with very little dissent. For instance, if two guys, to my knowledge, got convicted under this very section for murdering somebody and then burning the evidence of the murder by setting the apartment where the body lay on fire. Many, many instances of an application of Sarbanes-Oxley have been upheld because the language is so clear, and the present conservatives or reactionaries on the Supreme Court always say let's just look at the text. I mean, Gorsuch is notorious for just sometimes absurd readings on the basis of just literal readings of the text. Somebody who otherwise obstructs, influences, or impedes an official proceeding. That sounds to me like not just Trump, but a lot of his co-conspirators that Jack Smith mentioned, or even attempts to do so, shall be fined under this title or imprisoned. So first, I'd say the application looks textually solid. It may seem a little unusual where it's plucked from our massive body of statutory law, but it's been used again and again. And as it has made its way in other cases, I think there are about 1,000 people who have been convicted or pleaded guilty in the insurrectionary activities on January 6th so far. And I think somewhere between a third and a half of them were charged under this, with nary a protest from almost all of the district, indeed, just about all the district judges. One district judge objected, and that's what's led, in Fisher's case, and that's what's led to this appeal making its way up to the Supreme Court. So this is an important case. If this is thrown out, it's a real blow, not just to the prosecution of Trump, but also to the prosecution of an awful lot of people. Now, we get them on other bases: trespass, vandalism, et cetera, et cetera. But this was the one that went after the actual intent of stopping an official proceeding. And it's important.
I'm a little confused though, because the whole idea of disrupting an official proceeding is tied to this law, which was fairly recent, right? I mean, it started with Enron. There was no concept of disrupting an official proceeding before that?
I think there probably were lots of concepts. For instance, the insurrection statutes, which we have. But Smith decided, and he didn't know what the hell was going to happen like this. I mean, he's smart, but he's not, all-seeing. He decided, as you know, not to charge insurrection. He probably because he thought it was too vague, too ill-defined, et cetera, and to charge on the very specific language in this statute. I suspect he looked around and said, look, this statute's been used hundreds of times to go after people, jury tampering, bumping off possible jurors, threatening jurors, et cetera, and the language would seem to reach exactly what happened on January 6th. I'm going to use this statute. And it was at the time, it must have seemed like a very good idea, a very shrewd idea. It's now looking vulnerable. because one district judge and one circuit court of appeals judge in a dissent said it's unconstitutional, that they shouldn't be applying it so broadly. It wasn't intended that way. Now, remember, these conservative judges are all textualists and originalists. So they're sort of playing, the text clearly covers it. So what they're saying is, well, but the text was meant to only apply original intent of the statute to a financial circumstance rather than the certification of an election. So I don't know what to say about this one, Alan. It's scary to me.
Well, we're all becoming sort of, or trying to be knowledgeable about the law, watching our MSNBC and listening to our podcast. So there's this thing called a superseding indictment. Is that what it's called? Where you sort of add to it? Could Jack Smith add something to it that would work better than this?
The question is what, and I don't know. I don't have the answer to that.
You go for the Insurrection Act then.
Yeah, I think you could charge insurrection, but I think you could charge insurrection. I think conspiracy to rebel and use the old precedents of the times and the Civil War itself.
That would be an
but you hate to get these setbacks. You know, I mean, if Fani Willis is taken away, we'll get another prosecutor. But you'd hope that. I'm sorry, some interference.
All right, so we have some here throughout history. Autocrats have
been precedent to the final finding that he was disqualified under the.
What's going on here?
I don't know what that is.
Someone is dictating a question.
Oh, I see. Dictating a question, but
we have a question here. Throughout history, autocrats have been elected to office, at least initially. I wonder if you would be willing to comment on approaches to countering the election of Trump, who shows clear signs of being an autocrat.
I mean, clear signs. I mean, that's an understatement. He's like the model of an autocrat. Yeah, if he could only do it, and we're worried that he will. I have no special wisdom here. I'm like the rest of you. I'm pretty activist on the liberal side of the Democratic Party. I am shocked by what I hear people saying when they interview those Republicans in Iowa who participated in the caucuses and supported Trump. I'm shocked by the evangelicals and their protestations of faith and virtue and so on. And I mean, I think most of us in this community around Indivisible and the left of the Democratic Party see Trump as an astonishingly bad candidate for any office of responsibility, a grifter, a narcissist, etc. So I just think we have to really hope that Biden comes alive and has a last hurrah here in which he's really fiery and impresses young people and others about what he's doing and what he's done and how well governed America is. But I don't have a special remedy.
The only remedy is getting out to vote, I guess, right?
Yeah, get out to vote.
Mm-hmm. What is your take on Judge Cannon? Is she full in for Trump? And is there any, I would add to that by saying, is there any way to keep her from slow rolling this?
Now, Judge Cannon down in Florida. Now we're talking about the documents case. Yeah. So you all know that case. Trump went away with all these souvenirs, as it were, and a lot of them were serious national security documents with serious classifications as top secret. I'll be honest with you. You're not supposed to reason ad hominem or ad womanem, as I sometimes jokingly call it. Her parents are Cuban. She herself was born when they were in exile in Colombia. I think my read on her is that she is a classic right-wing Cuban American in the Miami area, and in her sort of upbringing and growing up. She's obviously was a good student, and everything I've seen about her suggests that she's not a very good judge and is, as they jokingly say, in the tank for Trump. So he lucked out. I mean, she seems to genuinely have won a little lottery to get this case after she was chastised by the Circuit Court of Appeals in her other rulings, in the preliminaries, the motion and back and forth on this and the searches. But you want if you're ever being accused of something, you want a very favorable judge. Trump has got one down there. He's also got some very tough prosecutors, and it's going to be a contest between the skill of the prosecutors and I think the skill, I guess, of the defense lawyers, but I think that's less relevant than the willingness of this judge to show favoritism. It looks to many of us if it's an open and shut documents case down there, at least on some of the points.
Here's one. Is there no remedy for Justice Clarence Thomas?
Well, we all face our mortality with stoicism, if not Buddhism. And I guess mortality would be quite a remedy for some of these justices.
It does seem unimaginable, though, that he would not recuse himself. I mean, not unimaginable because he won't, but that he wouldn't have to recuse himself with his wife being involved in the insurrection.
Well, we talked about, I mean, here's a parallel. We talked about is the 14th Amendment, Section 3 self-executing, meaning it doesn't require a judge or a process to declare you. Well, the ethics rules of the Supreme Court that we all saw promulgated a couple of months ago are, as you know, they're only enforced by each individual justice. I mean, Roberts was either not willing or not able to get the votes among the justices to make it a really tough ethics rule that has some enforceability. So, he decides his own conflicts.
Here's one, Tom. Why doesn't the Colorado trial court's finding that Trump did engage in an insurrection, while not a congressional finding, meet the test of the 14th Amendment, Section 3, so that the U.S. Supreme Court could uphold the Colorado Supreme Court?
Yeah, I think it, in a certain way it does, but as I've said in discussing this with others and argued here, that there is no mechanism except congressional legislation in Section 5 that suggests exactly how this would happen. So then you're left to, well, the ordinary mechanisms of state government have secretaries of states usually, or sometimes courts, as in Colorado, that have the power to keep people off the ballot. And the problem with that is what I would call a structural problem. We've already seen that the Secretary of State, or was it the Attorney General, one of the senior officers in Missouri already said, I want to get Biden off the ballot. And what's the allegation against him? Sort of the allegation against Mayorkas. He didn't uphold the laws of immigration or something, I don't know, the nation's borders. I mean, all sorts of complaints. Breaking it into 50 or so separate decisions, which would likely go in various crazy, directions, seems to me a bad structural idea for our Constitution and our polarization. And I think the Supreme Court will say it has to be done on a national basis. And I think the only logical place to do it is in the Congress. And we know the Congress will not be able to move. Right. There'll be a gridlock on this. I mean, they could pass legislation, but they're not likely to say that Trump was an insurrectionist, nor to say that anyone convicted in a trial can be held to be an insurrectionist if they wanted to give due process. So it's a sensible idea. It makes rational sense, but I don't think it's a practicable idea.
There's another trial we haven't talked about, and I just want to bring it up because the trial of Eugene Carroll involves our neighbor here in Old Chatham, Lou Kaplan, for those of you who don't know it.
You're a friend, right? You're a good friend, I think.
Friend, and he has a home here, has for many years. And I'm wondering, in that case, what can a judge do to control somebody like that in the courtroom? I mean, there's contempt. What other strategies are there?
You can boss him around. You can charge him with contempt. You can hold him in contempt. You can fine him. You could even jail him. But doing that to Trump at this point is probably, as we saw with Engoron, they call him Justice Engoron at the trial level in New York, because we kind of reversed the titles. Our Court of Appeals is our state Supreme Court, and here we call those guys judges, and at the bottom we call them justices. But Engoron notoriously let Trump talk at the end, even though Trump and Trump's lawyers and Trump's lawyers had not conformed to Engoron's request that if he wants to say something, he had to conform to certain conditions, not maligning various people, including his staff and so on. But in the end, Engoron just said, fine, go ahead, say something. And Trump said a bunch of denunciatory things. And I think the way to read that is that Engoron was saying, look, I'm almost out of here. I don't want to get in any more trouble. I don't want to have an appellate and, some issue that people say on appeal, I shut Trump up. I don't even want to give him the political gift of saying I shut him up. Let him blab and then we'll stop. And I think Judge Kaplan, who's probably tougher and more authoritative than Justice Engoron, he's pretty tough. I mean, he's kept Trump pretty much in check without using the contempt power. I think it's really the Trump effect. He just disturbs every norm in every setting, whether it's real estate or building or hockey rinks or the presidency and the Constitution. And he disturbs the norms in the courtroom. So if you're the judge, you ask yourself, is it worth holding this guy in contempt? And they fined him several times in Engoron's courtroom anyway, and they shut him up pretty good in Judge Kaplan's courtroom. But the guy is he's a little crazy, and people seem to be out there on the hard right to love this stuff. So I think it's the better part of what is it? Discretion is the better part of valor. I mean, I think it's a kind of let him blab. We'll be done with this soon. I think in Engoron's case, it clearly means, and it clearly means, I know how this is coming out. This guy's going to get hit. And in Judge Kaplan's, it's the same way. Jean Carroll is going to win a fair amount of money this time. That's all the case is about right now. He's already found you can't say these things about her. And now it's just a question of what he said when he was in the presidency.
She asked for 12 million, but the jury could award considerably more than that if they decided to, correct?
Yeah, or less. Yeah. And you'll remember this was postponed by this immunity issue. This goes back to the civil immunity. In a civil case, the Justice Department sort of denied her the ability to come forward on the trial and so on until Trump left. And now she's had her in these ensuing couple of years, 3 years really, she's had her chance, and she won that first under the tolling of the statute of limitations under New York's relatively new regulations about sexual assault complaints. She was able to have a trial and a judgment with $5 million of damages that he had indeed not raped her, but sexually assaulted her. I mean, for some reason, the jury hesitated to go the whole way.
Okay, we have one more question, which is from Adelia, so we better take it. And it says, what about the Manhattan DA Bragg case?
That's not from me. That's very funny.
Well, that's great, Adelia.
It's
Well,
from
what about
your alter egos who has got the password. So all good.
Oh, I see. It's because Adelia, you were sending out the Zoom connection with a whole lot to a bunch of friends and stuff.
Yeah.
Well, you all know that there's a little stretch on the Bragg case because the pro-Trump view of the Bragg case is he was paying that money to Stormy Daniels and the other young woman whose name I forget, is probably not so young anymore, in part to keep it away from his wife, to keep it down as an embarrassment. Whereas the accusation requires that the money be paid in relation to influencing an election. It's in that sense, it's like that language in Sarbanes-Oxley, in influencing the actual New York voting. And I think it's pretty open and shut that Bragg will win. I think the prosecutor will succeed, but I do think on appeal there are going to be real questions about the application of the electoral laws to this particular bribe. Do you follow what I'm saying? In other words, he had mixed motives here. Undoubtedly, he didn't want a lot of hassle in his family. And in that sense, he'd want to keep it quiet for that reason. But he also didn't want a lot of bad publicity in the election, and the brag is going after the election side of it. And there's a question about whether that would have been done. Is this just an excessive use of prosecutorial discretion? Would he have done it to other politicians who paid to shut up a sexual partner of some kind? So I don't really know. And that one's that's coming later in the spring, I think. A lot, let's go back to basics here. Part of what's wrong with what's happening with Fani Willis, part of what's wrong with Tanya Chutkan's allowing an interlocutory appeal, is that we're playing into Trump's desire for delay. And we have just got to keep our fingers crossed that Biden wins the election and Trump can't just wash away everything but the state prosecutions like the one in Georgia, which could get washed away by Fani Willis's being pulled somehow from her authority over this case or being a DA. And I think there's an awful lot of, if you look at this as a kind of a game, there's an awful lot of room for Trump to run out this clock. And I think the room is not diminishing, but enlarging in these last few weeks.
Great. So this is great, Tom. I'm just wondering if you want to spend 5 minutes just letting people know what to look for on that Chevron case and bringing it to the attention of anybody who doesn't know about it.
So Chevron is a precedent now more than 20 years old, as I recall, which seems to many of us to have taken the following view of administrative law. If the law about, say, fisheries or coal powered plants exhaust uses a general term, and the EPA, let's say, or the Fisheries Authority, whatever that's called in the United States, if one of these administrative agencies said, we've studied this, we've looked at it, we know how much coal dust and coal smoke is healthy or unhealthy, we know what it takes to preserve the New England fisheries and so on. Our judgment is based on research and so on and so forth. So as an administrative agency, we're taking the general term, protect the public health, protect the fisheries, and we're telling you what the rule will be. There's a whole right-wing song and dance about this is like a fourth branch of government and it's illegitimate, even though the administrative agencies are part of the executive branch of government, one of the three branches. And what Chevron is saying, or Chevron says, that in a case of ambiguity or lack of clarity, you should defer to the experts in the administrative agencies, the environmental experts, the fisheries experts, the coal experts, whoever. The government has hundreds of thousands of people working on all these problems, and Congress doesn't know much about these problems. And by the way, neither do our judges, who are usually lawyers who came up through law school and, practicing corporate or criminal law or something. They're not experts on what the FDA should classify as a drug or a supplement. These are very fine technical questions. And in my own view, any modern government is going to have, that's working well, is going to have complex administrative agencies with many, many experts studying these matters and making decisions. And there is no way that an electoral body like the Congress of the United States can decide fine points of the COVID vaccine or coal dust or occupational safety. And so when it comes to legislating, congressional staffs come up with fairly general terms. We're protecting this, we're protecting that. The waters of the United States was a case that was decided in last term and so on. The position of the most aggressive of the justices on this, Justice Gorsuch, is this is an illegitimate lawmaking authority in a kind of a fourth branch of government. And as far as I can tell, he'd like to throw them all out and say everything belongs to Congress, which would really gum up the works. We wouldn't have effective administrative agencies on the environment or on any of these matters. And let's say health and the environment are probably the most important, unless you had experts studying it and issuing refinements of the general terms of congressionally passed law. So if they throw out Chevron, what they're going after is the administrative agencies. They're trying to geld them and make them powerless. And it also throws very complicated and difficult scientific and other questions into the hands of a huge amorphous body of ignoramuses, to be honest. And I don't mean that. I mean, I'd be an ignoramus too if I were a congressman. You know, they just can't know that much about the very fine details about the fishery stock in off Maine, or how lobsters are doing or whatever. These require people who are paying a lot of attention day by day.
And the judges will have an avalanche of cases on their already crowded.
And the critique, there is a critique, which is not just the liberal critique, which is Justice Kagan has been very strong in this. What's happening is you're just empowering, you know, Congress is not actually going to exercise its power. They're too busy with other things, and they can't get down into the grass like this. So what's going to happen is Congress will have come up with some general term for the protection of the health or the safety or whatever of the American people. And then it'll be thrown into court, and some judge in Texas or Connecticut or wherever will be, oh yeah, in my opinion, it's this, that, and the other. And you know that judge can't possibly be somebody who came up, you know, as a food and drug researcher or something. It's at its extreme, at least, it's a really destructive idea that to me looks almost anti-modern, against the modern state, not just the administrative state. Whether it will go that far, I don't know. I was really struck that the NPR Supreme Court reporter, whose last name is Johnson, I forget her first name, said she didn't see the fifth vote for the conservatives. And that's because Coney Barrett raised some questions about this in terms of an avalanche of legislation. So I'm not sure what's going to happen on Chevron. I mean, I think the betting would be the right wingers are going to win, but there are more of them and there are enough of them, but it's possible they won't. Kavanaugh seemed to be on the Gorsuch side of this, and that was a little worrisome.
Where do you think Roberts is with it?
That's what I don't know. I mean, I think he's being coy, but he'd have to join Barrett, right, to give us the majority on the other side and uphold it. It almost certainly it'll be trimmed a bit, which is fine. You know, if you're a moderate and you're willing to compromise, but if they throw the whole thing out, I really do think Gorsuch is a fanatic on this. And if he gets to write the opinion, say it'll be like Thomas writing that gun opinion in Bruin, you know, which basically made it impossible for New York City to have reasonable safety regulations on on guns.
Or Dobbs. Well, there you go. Well, what a time we're living through. Thank you so much, Tom, for walking us through some of these very complicated issues. And thank you all for being here tonight, and we'll catch up with you again.
And thanks, Alan. And I'm very aware as I sign off just how hard it is to bring all this massive complications into focus, really. But we should all keep trying, because it's part of our effort to get out the vote and persuade people.
Great. And thank you, Aileen, for walking us, dealing with the tech part of this, and have a good night, everybody.
Thanks, Tom.
Thank you. Thank you, Aileen.
Thank you.
Thank you.
Thank you all for being here. I'm going to stop the recording. And Alan, if you could just stay on